So here we have the case of Quaneesha Nicole Johnson. She's a 30-year-old woman. She was charged with malice murder of her boyfriend, DeMonte Smith. DeMonte Smith actually has a prior domestic violence charge on an entirely different victim from 2018 in DeKalb County. So I know we've all seen, for the most part, most of us have seen court TV or the national news about the case, garnered quite a bit of attention. We know the jury acquitted her of second-degree murder, which was malice murder. And basically, the jury found that a certain degree of intent was lacking. They ultimately found her guilty, though, of voluntary manslaughter, I think cruelty to children. I want to say maybe another charge. But those are the main ones, and those were the ones that carried the most time. She was sentenced to a total of 20 years. And to break that down, the judge basically told her that she was going to do 5 years inside prison, another 5 years on house arrest, the remaining 10 to be served on probation. All right, and so basically, from the police report, the facts of the case are that on November 26th or 27, 2022, Quaneesha Johnson went out with some friends, went out clubbing, left her kids with her live-in boyfriend. I guess her boyfriend told her that she had a curfew and she was supposed to be home by 6 a.m. So she didn't make it back by the curfew, apparently. And her family and Mr. DeMonte Smith, the deceased, were attempting to call her with no response. It wasn't until 9 a.m. that the family finally made contact with her and decided to do a conference call with her and the boyfriend, who was taking care of the kids. And apparently I think the youngest kid is, the deceased is the father of the youngest, I believe. Now in the call, the boyfriend actually threatens to hit her when she arrives home. He's quoted as saying, "When you get here, I'm gonna beat your ass." So, that is a criminal threat. I know in California that's a felony. You could get a felony for that, and most of the time they do. In fact, we'll charge you very fast, very quickly, and haul you off to jail just for that. And so, even at one point, DeMonte Smith is quoted as saying she should be scared because she knows that she was wrong for staying out late. Meanwhile, while all that's transpiring, three of Quaneesha's family members are also on this conference call. Now, Quaneesha makes it home. Her and her boyfriend apparently start arguing, whatnot. Apparently got to a point where Quaneesha thought it was so bad that she had to call the cops. She had to call 911. And when she does, she tells them that DeMonte had threatened her and had even assaulted her 2 weeks prior. Now I believe that right there is enough to make an arrest. Especially, and I'll get into this a little bit more without going into too much detail and, burning 20 minutes on it. DeMonte had a prior domestic violence charge, was on probation, had just, been released not too long prior to this incident from either jail or prison. Okay, so to me, that sticks out to me, and the cops not doing their job they should have. Obviously, I'm assuming they must have ran this person's name and would have seen that he's on probation for a domestic violence charge. And now you have another woman saying that, she was assaulted 2 weeks prior. I believe they messed up here at this point. But not to go into too much of detail of that right now. It's also known that the daughter had told police that DeMonte had hit Quaneesha with a pole, and that she did hit him back. Okay, so now the cops arrive and make contact with the couple, or it's possible that she was escorted back to her home just based on the threats. I'm reading the police report and in some of the accounts online, um, um, and I believe she may have been escorted. But the bottom line is, the police ended up at her home. She talks to the officers about what transpired. She tells them about the threats, the prior threats, and it's at this point that Demonte and Quaneesha start arguing in front of the cops. All right, and Demonte actually tells Quaneesha in front of the cops. This happens in front of the cops. That when the cops leave, he's going to beat her ass. Quaneesha tells the cops, "Hey, did you hear that?" And at this point, it gets a little unclear exactly what happened. Did the cops hear it? I believe they heard it, and they more or less just brushed it off to the side. And this is where she asked them about self defense. I'm paraphrasing what she said, but she basically said, "Hey, if I shoot him in self defense, what will happen to me?" To put that into context. And then, according to the reports, according to online accounts, everything, it's not clear what the cops said in response to that. But what it is clear is that they did hear it. They were told that. To me, that's another fact that right then something should have been done. Because this was just a situation waiting to blow up. That it was going to go bad. It was going to go bad eventually. And because the police knew that she had a firearm, they actually requested that she put it back in her car. And she did. She complied with that. She goes back into her home. She ends up, apparently at one point, comes back out, retrieves the tire iron and the firearm, goes back in. And that's when this whole situation really gets live. Gets real after this. What she testifies to, and I've seen her testimony, she testified that he made movements toward her, basically gonna almost like charge her, like rush at her. That's when she hits him with the tire iron. He does it again, and that's when she draws down on him, fires, kills him. All right. Kids weren't in the room. Kids were in an entirely different room. Right. Now, like I said, I watched her testimony, and I think she was a credible witness. There was the testimony about her telling her daughter to tell the cops that Demonte hit her. And I think the prosecutor tried to twist that up to where it was like, oh, see, she, her intent was this, she was having her kids lie. But I mean, she had already said that Demonte had hit her on a previous occasion. And even the daughter, I believe the daughter testified to that effect, that she was hit by Demonte. So that one right there wasn't entirely clear. So I if I'm a juror, I can't say that was inconsistent testimony or deceptive testimony or anything like that. I think overall, I believe she was a credible witness. That's what I believe. If I had been a sitting juror, I would have deemed her credible. And I believe I think she should have been found not guilty. But I'll get into that. So let's break this case down a little bit more to some smaller parts. Let's talk about some of the legal errors, some of the laws in Georgia, things like that, and how I think it would have made an impact on this case. This case I think is also it throws salt on a wound, in that many women and men go through domestic violence situations. For myself, it hits close to home for me. My little sister was found murdered in 2015, and she was found beaten, bruised. The cops knew, we knew who did it. The cops investigated the guy, I mean, the guy's still free to this day, you know. So you know, it hits close to home to me, and that's why I chose this video as one of my starting pieces of my channel, because I think it's important to highlight, you know. So yeah, I will. Let's break this down a little bit more. What I want to do is talk about the legal errors that happened in this case. Okay, there's two specifically. The first one was about a potential witness that should have been brought to the table. Not everything is clear about what this witness would have brought to the table or anything like that. I'm assuming it would have been the victim from the DeMonte's prior domestic violence case. What happened was I guess when the defense was trying to call this witness, they refused. They had a change of heart after speaking with the victim's family. I think it's patently wrong for a witness that's about to testify in a case to go speak to the victim's family. I think that is a legal error. I don't know what the laws are in Georgia on that, but in California, that's certainly a reversible error. It's witness tampering is what it is, and I'm pretty sure Georgia has the same type of law on the books somewhere. One of my thoughts on it is, and the question I think I have in my mind is, did the prosecutor have anything to do with this? You know, not all prosecutors are bad. I'm not saying that, but as a man who has been around the legal system for quite some time, I've seen my fair share of prosecutors. You know, well over 50% of them, they don't play fair. Okay, they don't play fair. They don't care. They're more about getting convictions and just putting people away. So my question is to what extent did the prosecutor play in this? You know, most prosecutors are not themselves going to potential witnesses and getting them not to testify. What they usually do is they usually use a DA investigator or a local PD, local investigators, to have them go and speak to a potential witness. And that's usually how they try to prevent somebody from testifying. It could be threaten them with jail time. They could be on probation, could be threatening them to violate their probation. So many different things. There's so many ways that I've seen a prosecutor dissuade a witness, basically. Maybe, and I think it's more likely that somehow the prosecutor probably spoke to the victim's family, and then, the victim's family ended up speaking to the potential witness. But anyways, the bottom line is there was witness tampering in this case. I think this is a ground that's going to be raised on her appeal, and hopefully, it helps her, it gets her conviction reversed. Now, the second piece of evidence that I believe that it was error not to admit that they excluded it was a 911 call of a previous domestic violence that pertained to DeMonte Smith. The judge didn't allow the evidence, excluded it. I'm assuming the judge must have excluded it on the ground that it was more prejudicial than probative, and on that ground, said it wasn't coming in. Even though, I think what I need to highlight here is at Quaneesha's sentencing, this judge makes a reference to the 911 call that was excluded. Now, I think that's important because why make that reference? I think the answer to that is the judge obviously believed that to be an important piece of evidence. And I think that's why she took a more lenient stance on some things, which I'll talk a little bit about later. That's the bottom line for this from a legal standpoint is that it's certainly unfair. Um, it violates Quaneesha's right to a fair trial. Numerous constitutional provisions. Um, you know, I'm arguing that the evidence should have been admitted to show the deceased's propensity for violence, domestic violence at that. I don't know to what extent the victim's criminal history was admitted, but I'm going to assume that none of it was admitted just based on the ruling of the 911 phone call. I did a quick search, um, poked around in some of my resources, and I found court documents pertaining to DeMonte Smith's prior domestic violence charges. And on September 19th, 2018, the deceased was charged with a host of crimes, including family violence, battery, and cruelty to children. Eventually, he pled out to 2 counts and he was given probation. Now, not allowing that to be admitted, and like I said, I'm assuming, I haven't seen anything to the contrary or to support it or go against it. It would make no sense to me for the judge to admit his prior criminal history through court documents or whatever if they're not even going to allow the 911 phone call. So I'm pretty sure they didn't allow it, and I think it was big. I really do. You get that kind of information in front of any jurors in a domestic violence case like this. A murder case, but that has that surrounds domestic violence. I think this right here would change the outcome. Now, had it been admitted, would all the jurors have voted not guilty? I don't know, but in the legal realm, you can show that that there was an error made, and that it was prejudicial if the evidence that didn't come in could have even persuaded one juror to vote not guilty. And if you can prove that, if the error could be shown to have affected the mindset of just one juror, then prejudice is it's shown. And so my point is this, and this is what I want to highlight. It's the legal error in the judge not allowing the 911 phone call to be admitted. Not allowing Mr. Smith's prior domestic violence charge to be admitted. In a legal sense, there's different standards. Abuse of discretion standard. There is a reasonable probability standard, a likelihood of a different outcome, clearly erroneous standard. These are all legal standards. And if I'm not mistaken, I'm obviously not an attorney. I am a paralegal. This would be, because it's a rules of evidence, it would have been governed by the abuse of discretion standard. Most likely that's what it was, which is not really a huge standard, but it kind of gives a lot of leeway to the judge to admit or exclude certain pieces of evidence. But it also, impinges upon Quaneesha's Sixth Amendment right to, I think it's a compulsory processes to present a complete defense. And I think that's where the error lies. And, although Georgia has its own court system and it's a state, federal law actually governs. Federal law, U.S. Supreme Court law trumps any state law. And so, I think both of these errors taken together on her appeal, I think one of them, I'm not sure if they're going to have to do what's called a writ of habeas corpus. Writ of habeas corpus is basically like an appeal, but it concerns stuff outside the record. So I'm thinking that the second error, which is the witness tampering, I believe that might have to be brought up on a writ of habeas corpus. The second error with the 911 phone call would be on her direct appeal. So, yeah, I really think there would have been a different outcome. I think they were prejudicial. And, I believe that they will probably overturn her convictions. Okay, so let's turn to the judge now. You know, the judge, like I said before, she referenced the 911 phone call that wasn't admitted, right? And you all seen that. And the judge said it straight up. The police did not do their job. Okay. I'll quote her. She says, I believe, she's talking to Quaneesha, I believe you took all the necessary steps to ensure your safety after Mr. Smith had threatened to inflict bodily harm upon you. That's what the judge said. So she's seen this case for what it was, I believe. She's entirely accurate. These officers did not do their job. As a cop who gets a domestic violence call, and you respond to it, you have two people, or whatever. One is alleging that the other assaulted them, 2 weeks prior, and right now they're still making criminal threats. It's hard to fathom, but I don't see any situation where that person should have been let go. This person's making allegations that this person threatened them and assaulted them. Hey, that person goes to jail, or at least they should, but here they did absolutely nothing. I don't know what that's about, but it almost seems like they had somewhere else better to be, maybe, rather than make an arrest and have to, spend the rest of their shift doing paperwork. I don't know. And I mentioned it earlier about, them running DeMonte Smith's name in the system, in the database. They obviously would have seen that he was on probation for prior domestic violence. Now, imagine this. You're an officer. You come to a domestic violence situation. People are alleging, like I said, criminal threats, assault, whatever. And it comes back that this man, just got out of jail, still on probation for a prior domestic violence. How do you not arrest this man? How do you not arrest him? That's the part that I don't get. And I know the judge obviously seen that. I just don't get it. I really don't. Had they arrested the man and, even if it was on a 24-hour hold, whatever, it would have quelled the situation, at least for the time being. DeMonte Smith still may be alive. You know what I mean? Quaneesha Johnson would not be going to prison. So yeah, I absolutely agree with the judge that the police didn't do their job. And that's the bottom line. Now, the question I have is, did the judge act fair in her sentencing on this case? Well, she did allow the defendant to stay out on bond, even though she's convicted, even though she knows that she's going to prison. I've never seen that, honestly, in all my years of doing time, all my years of being a paralegal and helping and litigating cases. I've never seen that. And yes, I have been incarcerated for quite some time. But that actually surprised me. It really surprises me. But what I think it's evidence of is that I think the judge feels maybe she got it wrong. Maybe she feels guilty for not allowing the 911 phone call in. But here's the thing. In criminal law, I'm sure it extends to possibly civil law and, most other judge-oriented proceedings. But there's something called the 13th juror. And to give that a little bit more context, 13th juror is basically, you got 12 regular jurors that are seated, and you as the judge have the power to um, uh, reverse whatever the jury found. Okay. Um, and I don't know if he could actually acquitted her, because I don't know what the law is in Georgia. Um, but it's rarely done. It really is. It's not something that is used all the time. Even though I think that they should obviously use it a lot more. But they just judges are just not gonna overturn anything that the 12 man woman jury found. And I'd like to contrast this with something, and it's actually a case from Georgia, and this is just a stark reality of the unfairness sometimes. So I want to point out the unfairness here. In 2019, a Superior Court judge in Georgia, which is the same state that Quaneesha Johnson had her trial, invoked the 13th juror statute to grant a new trial to a former judge who was convicted of murdering his adoptive son. This judge, his name is Paul Hamilton. The judge was sentenced to life in prison for murdering his adopted son. And this is just crazy right here. Usually the defense has to submit a motion for a new trial based on this, and ask the judge to act as a 13th juror and grant him a new trial. The defense attorneys in this case did not even do that. Okay. The judge, without the defense doing anything, asking anything, any type of request, ordered a new trial on his own motion. And I don't understand it. Like, how can you do that, in that case? And I don't want to get off topic, but it just astounds me that this 13th juror statute was not invoked in Quaneesha Johnson's case. But the judge did give her a break and not put her back in custody. So I think that's, at least she gave that to Quaneesha. And I think, in order to leave somebody out on bail when they're already sentenced and stuff, I believe they have to look at the chances of her prevailing on appeal. And I think the judge may have looked at it like, hey, I see this coming back to us from the Court of Appeal, and she may just get the case tossed out. So I believe this is a clear indicator that the judge believes that the grounds that she has for appeal are meritorious. But yeah, again, I'm surprised by the judge's ruling on leaving her free on bond, knowing that she's convicted of manslaughter, knowing that she's, been sentenced to prison already. Because, they don't want the defendant to get any silly ideas of skipping bail or skipping out on justice, and I get that. I want to conclude with this. I want to point out two laws that are on the books in Georgia. The first one is Georgia's Family Violence Act. That's the name of it. It's designed to protect individuals who are abused by present or past spouses. Okay. That law did not protect Quaneesha November 27th, November 26th, 27th. The law failed her. Okay, the officers that responded failed her. And they pretty much made clear that they didn't give a damn about this act when they responded to that incident. The next law that I want to point out is Georgia has a standard ground law, and I'm sure we're all familiar with that, or we've at least heard the term. What that means is that you do not have to retreat when you're under attack, as long as you're not doing anything unlawful, which I don't think Quaneesha was doing. She wasn't doing anything wrong. She, even the judge recognized that she did the right thing by calling the police. So those are the two laws that I really wanted to point out, and just how the judge and the police handled this situation, I just, I think it was a slap in the face, and I don't think justice was served in this case. No one really knows what happened that night other than Quaneesha Johnson and DeMonte Smith. And that's the point that I'm trying to make here is, regardless of whether you think she's guilty, whether you think she's innocent, the point is that you must prove beyond a reasonable doubt that this person is guilty, okay? Utilizing the entire picture, not just pieces of the picture. And that's exactly what happened here. There wasn't a full picture put forth to give the jury enough to, render a just ruling. And that is the priors of DeMonte Smith, the 911 phone call, as well as the witness tampering. If I was a juror in this case, I absolutely would have voted not guilty, just based on the standard ground law. And if I was a judge, I would have invoked the 13th juror statute and gave her a new trial. Now, I appreciate you very, very much for watching my channel, watching this video. I hope you will like and subscribe. I'm open to suggestions as far as any upcoming content, any cases that you've seen that, you're specifically interested in, and please, help me out by suggesting, anything that I may have left out on any of my videos, more stuff that you would like to hear about. And I can, I do the homework and I'll get on it, you know what I mean? And I always do follow-up videos, and like I said, I'm new to this. And so, bear with me. But I really, truly appreciate you watching this video. And I hope to have you as a subscriber to my channel to watch future content. So I'm out. God bless you. Take care.